Hear ye, hear ye, hear ye. The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business. Draw nigh, all ye having business before this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. Good afternoon, everyone. We will begin with introductions from the court. I am Mike Havican, and I am the Chief Justice. And now, by order of seniority as to service on the court, the other members of the court will introduce themselves.
Good afternoon. I'm Lindsay Miller-Lerman.
William Castle. Good afternoon.
I'm Stephanie Stacy.
Good afternoon. I am Jeff Funk.
Jonathan Papik.
And John Frederick.
Thank you, members of the court. Our bailiff today is Josh Sacheray, and that takes us to our case for today, which is State ex rel. Collar versus Evman. Both sides have up to 15 minutes to argue, and Mr. Venzer, good morning to you. Mr. Hamilton, good morning to you.
Good morning.
It's my understanding you're going to split time.
Correct.
And who's going to go first?
I'll go first.
Very good, Mr. Venzer. But before you approach, Mr. Gutman, good morning to you. Does anybody have any questions before we begin? No, you understand you have to keep track of, you're going to split your time equally. Mr. Venzer, then you may approach and you may proceed.
Chief Justice, Your Honors, and may it please the Court, my name is Tom Venzer, here on behalf of Ms. Latasha Collar, the mother of Nia Bell, who is a student benefiting from a state-sponsored education scholarship program. My plan is to speak for 5 minutes and hope to reserve 2 minutes for closing. The rest of the time will be for the respondent, which I understand will be covering other issues as well, but I hope to address questions about this type of appropriations not being subject to the referendum power. LB 1402 clearly constitutes an appropriation for an expense of state government and is therefore not subject to referendum. This is clear from the plain language of LB 1402 in Article 3, Section 3, but looking beyond the plain language, it's also clear from the object statement of the referendum petition. It's further clear from this court's case law, which provides a constitutional definition and meaning of appropriation, as well as the case law properly interpreting the meaning of expense. And finally, it's clear from the legislative process for establishing appropriations. Because LB 1402 fulfills a referendum exception, this court should issue the writ of mandamus sought by Ms. Collar, because 1, she has a clear right to relief sought. 2, there is a corresponding clear duty on the respondent to act in a manner to keep the referendum off the ballot. And 3, this is the only plain and adequate remedy available in the ordinary course of law. And so to approach the issue of the appropriation...
So is this the appropriation, or is there an appropriation bill, and is that the appropriation?
So I think what's important here to understand is that the language of LB 1402 is very clear in stating that it has funds appropriated. That is, you'll find that both in the plain language of the bill, Section 1, subsection 1A, as well as in Section 1, subsection 7, where you have the provision for an intention to appropriate $10 million from the general fund to the state treasurer for the purposes of education scholarships for kids.
If 1402A didn't exist, would money be forthcoming?
Well, 1402A and 1402 are they're basically interwoven and intertwined, because it's 1402A and the language that's in that bill that triggers the appropriation for...
Are they the same act?
Excuse me?
Are they the same act?
No, they're not the same act, but the two bills basically go through the legislative process simultaneously. So again...
But they're not the same act.
Well, but again, you can't have... What you have here is basically, in the object statement of the petition, is you have an attempt to go after the $10 million that's appropriated for this program. So by going after LB 1402, that ends up indirectly attacks the appropriation that is within LB 1402 and LB 1402A. So the bills have to be coupled together, because that is how the legislative process is played out. in terms of creating a procedural structure by which A bills are triggered by the underlying bill.
If 1402A didn't exist, would money be forthcoming? I beg your pardon, Justin.
Well, yeah, so I would say if there was no such thing as appropriations bills or A bills that went forward with it, then we would also look to basically the plain language of this legislation. Plus, we would look at the case law and the constitutional definition of what an appropriation is. And when we look at that, we basically look at the long-standing definition through cases like Norfolk Beet Sugar Company versus Moore, where the court held that to appropriate means to set apart from the public revenue a certain sum of money for a specific object in such a manner that the executive officers of the government are authorized to use that money and no more for that object than for no other. And again, LB 1402 meets those criteria. It sets apart from the public revenue from the general fund a certain sum of money, $10 million, for a specific object, which is scholarship funding and education scholarship money for children. And it's in such a manner that an executive officer, the state treasurer, is authorized to use that money and no more for that particular thing. So if A bills didn't exist, or if there was, you would have basically, the constitutional definition there of an appropriation met.
What's the answer to Justice Miller-Lerman's question?
Sorry, could that one be repeated?
If the A bill didn't exist, would any money be forthcoming?
I think basically, the way the legislative procedure has operated is that when you have a bill that authorizes an appropriation, an A bill comes with it. So again, the A bill is the completion of the legislative act to create an appropriation. So those two bills go hand in hand, and that's what we're dealing with today. We're not dealing with that.
But the A bill hasn't been referred. So why are we dealing with it at all?
So again, we're dealing not with a hypothetical situation where there isn't an A bill, but there is an A bill in this situation, and the two are coupled together in order to understand the legislative's intent to create an appropriation of $10 million.
Have they both been referred?
They haven't been both referred, that is correct, but again, the language in 1402 is what directs the $10 million in the appropriation, and even the object statement of the petition recognizes that it's an attempt to go after the $10 million and not merely sort of the operational directives of LB 1402. So again, there's a recognition that the two of them are inextricably linked, and also if you were able to and so I would say that, again, those two bills are just sort of tethered together. And by going after LB 1402, there's also an attack on the appropriation as a whole, which is completed through LB 1402A.
If there were no 1402A, would the treasurer be authorized to draw money from the treasurer based upon the language in 1402? Solely upon that language.
Again, I think in that situation, we would go back to looking at the case law definitions for what an appropriation constitutes.
So your answer is in effect yes.
Yeah, I think you would look at the case law on that question to see if an appropriation was established.
In this instance, does that mean that the treasurer would be authorized to draw the same amount twice? Once based upon 1402 and once based upon 1402A?
No, I don't think that would be the case. And I also see that I want to reserve my time also for the respondents.
Very well, thank you.
Thank you.
Thank you very much.
Thank you.
Mr. Hamilton, good morning to you.
May it please the court.
Good afternoon, yes.
Thank you. Good afternoon, Your Honor. May it please the court. The Education Scholarships Referendum is invalid because it seeks a referendum on an expense of the state government. Before expanding on that point, however, I want to offer a few comments on the timing of this lawsuit as well as yesterday's litigation. I think all the parties share a view that the accelerated timeline for these suits is not ideal. We think a solution to this exists in present-day statute in 3214-12. Subsection 1 authorizes mandamus litigation after the Secretary of State disqualifies a ballot measure. Subsection 2 is the cause of action that Ms. Collar, as well as the relators in yesterday's cases, could have sued under. It authorizes any resident of the state to seek an injunction against the Secretary of State to remove something from the ballot for legal sufficiency reasons. Now, this court's Lemon against Gale decision on pages 302 and 303 seem to suggest that a legal sufficiency determination is a prerequisite for such litigation. We'd encourage the court to revisit those paragraphs and hold that such cases are ripe for litigation as soon as signatures have been turned into the Secretary of State for verification. Had that been the rule, this case would have been able to have been filed in Lancaster District Court as early as July 17th when the interveners turned in signatures to the Secretary of State's office. Yesterday's lawsuits would have been able to be litigated as early as July 3rd.
Could the legislature in that statute say as much as you are suggesting?
We think the text is all there in the statute, and that Lemon against Gale, as well as to an extent Wagner, is the challenge. Wagner, for example, talks about this court reversing a decision of the Secretary of State, and Lemon says that the Secretary of State is required in the first instance to consider legal sufficiency. So that is the language we encourage.
The statute does not presently contain language that says upon the tender of the petition signatures or anything comparable to that, does it?
Yes, I think it suggests that the Secretary of State's legal sufficiency determination is occurring at the end of the process.
Yes.
But 32-14-12 sub 2, we don't see anything there that suggests that a legal sufficiency determination is a prerequisite for a cause of action under that statute.
Was there a legal sufficiency determination here?
There was. He made that determination in his, or at least announced it in his August 30th press release when he said that the referendum will qualify for the ballot.
And has his position changed?
Yes. He believes that the referendum is not eligible for the ballot. He has not...
So has he decertified it?
He has not. Out of respect for the fact that the court accepted this as an original action and a desire to see this court make the final determination, he has not changed his position in a way that would moot this case. But we have briefed the case as we have because of the position that he has taken on legal
If this court were to not find the writ indicated and would deny the writ, is there anything further the Secretary of State can, will, should, may do? Or will he follow the writ, or follow the order of the court?
Well, we'll follow any order of the court, of course. But I think it depends what the order says. If the order says that the case is dismissed for procedural or ripeness reasons, then Secretary Ebnen would feel like there hasn't been a decision on the merits question and would go with his view of the law, which is that this is ineligible.
What would be the next step when that happened?
We will at the same time encourage the interveners to file a writ of mandamus against
So that short box that we're in just got shorter.
Yes, though the merits issues have been briefed and argued. I don't know that the court would even need to hold oral argument again, given today's events. Just a few comments on the merits. There are two issues. One is whether this is an appropriation. The second is whether it's an appropriation for the expense of state government. The answer to both is yes. 1402 and 1402A are inextricably intertwined. If one goes away, the appropriation is invalid, and the purpose of the appropriations exception is the protection of appropriations. If the court allows the...
How do we know that's the purpose?
Well, I don't know what other purpose there would be, if not the preservation of appropriations. Bartling talks about the desire to prevent the uncertainty and delay that would happen if there are appropriations that are subject to the referendum. And if the 1402 section 1 is carved out, 1402A is essentially nullified. The state treasurer will not be able to draw from that pot of money to do anything. And it is, in all intents and purposes, a referendum on appropriation.
What's a legislative appropriation that's not expense for state government, or expense of the state government?
Right, so the test is an ordinary running expense, and we think something that would be extraordinary would be perhaps a very large public benefits program. Consider, for example, if the state adopted a program providing free health care for everyone or large numbers of citizens. That would be extraordinary. That isn't the sort of thing that
How large is large?
I don't know, and I'm not able to. I don't know that the court has to decide that line. I can tell you though that this is a $10 million appropriation out of $1.7 billion that the budget appropriates for state aid to individuals, and that the Bartling case specifically talks about immense appropriations being subject to a referendum. This is not an immense appropriation, and we therefore see it as unfit for the ballot.
Is volume the only line of demarcation?
I beg your pardon?
Is volume the only thing we use for a line of demarcation, what is and isn't?
I don't think so. I think there's a determination about whether it is ordinary, and we cite Black's Law Dictionary, which defines ordinary as normal, as kind of in the course of events. And there are other scholarship programs in Nebraska in the budget. In fact, LB 1329 and 1329A from this last session authorized the Nebraska Career Scholarships Program. The Access College Early Scholarships Program is another example. So we see this as fitting comfortably within the wake of other scholarship programs in the budget. And I see that we are running low on time for Mr. Benzer's rebuttal. Thank you.
Thank you very much. Mr. Gutman, good morning to you.
Good afternoon, Mr. Chief Justice, and may it please the court.
Excuse me, good afternoon.
That's okay. Before addressing the merits of this case, I would like to briefly address some of the practical issues raised today and brought by this case. Here's what we know. As of 24 hours ago, Secretary Ebnen made 2 public proclamations that the referendum qualified for the ballot. At 4 p.m. yesterday, Secretary Ebnen filed a brief confirming this position with a caveat. If the court dismisses the case in the next 3 days on procedural grounds, he will decertify the referendum for the ballot.
Public proclamations, are you referring to press releases or to some other official document of the Secretary of State?
Both, Your Honor. So there has been 2 press releases, which has been the normal trend over the past several years about how Secretary Ebnen has released certification decisions to the public. So he'll announce it through a press release. Because of the expedited nature of this case, we do not have it in the record, but I can state that certification letters have been sent out to the sponsors. So both of those together, he has announced that it will be certified. He tries to ease the sting of a possible decertification by saying that he would encourage the interveners to file yet another 11th hour lawsuit. This would presumably require more arguments and more briefing before Friday.
Is there a process in the Constitution or statutes to decertify?
We believe that there's not, Your Honor. There is a process in the statutes for Secretary Ebnen to certify, and that requires him to make a legal sufficiency determination. It requires him to notice the sponsors, which he has done. There is nothing in the statutes that we're aware of that says that he can revoke that decision. And I think that his threat of revoking the decision threatens the credibility of certifications generally.
So if a Secretary of State has a letter, he says, send out one that says you're decertified or that you're not certified, and he gets a letter presented to him that says you're certified, and he's busy and he signs it, he can't fix his mistake.
I think that there might be extraordinary circumstances in which he could clarify where he's at. But
isn't a scrivener's error almost the antithesis of an extraordinary circumstance?
It could be, but that's not what we have here. And I think that this possibility is...
I guess what I'm trying to do is test the hypothesis that you present that the Secretary is without power to change his certification decision. Do you really mean that, or is he's without power to do it in the way that he's proposed to do it?
I think that in the way that he's proposed to do it, and I can't cite you to a case that says that, but I think that there's equitable principles. I think when the Secretary of State tells the people, now remember, we're dealing with the second power reserved, a fundamental right. When he tells the people, I have certified for the ballot, they rely on that. And as lawyers, we advise our clients that when you get a certification, you're on. I think if there's a rule announced that says, actually, we need to be advising our clients that a certification doesn't mean what it says, and we need to be inundating the court with possible litigation, more original actions in the off chance he decertifies, I think that that's a bad result for lawyers. I think it's a bad result for the court. I think it's a really bad result for the public. And I will just go to Cheney versus Ebnon. This is a 2020 decision from this court. In Cheney, the court said that the Secretary of State, the court said that it's not confined, the court is not confined to the Secretary's certification deadline when it's dealing with taking something off the ballot. If the Secretary erroneously puts something on the ballot, the court can issue an order taking it off. But the opposite is not true. If the ballots have printed and he makes an erroneous decision, the court can't order them to be reprinted. There's federal laws governing when ballots must be printed. And so that goes to this point again about, I don't think based on equitable principles that he can decertify a referendum at the last second and basically prevent any judicial review.
In light of what you're saying, what are you asking from this court to address this situation?
We respectfully ask and we urge a decision on the merits. I will be very candid. Our frank concern is that if this court dismisses this case for lack of jurisdiction or basically a procedural ground, that there will be a decertification issued on Friday afternoon and there simply will be no time.
Well, are you suggesting we don't have jurisdiction because of a notary issue?
We have raised that. We have flagged.
So are you retracting that argument?
Seemed counterproductive to what you're just suggesting now.
Well, certainly. I mean, I think we flagged the issue about a notary. At the same time, we received a brief that says, if you accept that, basically we're kicking you off the ballot and you will have no recourse. It's an unfortunate situation. We still stand by what we say in the brief, but
The cases and statutes that you cite in the brief do not include the more recent electronic notary statutes, do they?
They do not.
And what effect, if any, do you perceive from those new electronic notary statutes?
There's some confusion about where a notarial act takes place. That was our reading of the Electronic Notary Act. If it happens in another state, we recognize that. The statute recognizes and adheres to that.
So if Nebraska and Texas have similar electronic notary provisions with respect to registering with the Secretary of State, what state does that refer to?
I don't know. That is the confusion that we saw in the Electronic Notary Act, is it does recognize notarial acts out of state as if filed here. It just is not clear where the notarial act takes place. Turning to the merits of the case, Nebraska's narrow exception to the right of referendum applies if and only if three requirements are satisfied. The subject enactment must be an appropriation measure, it must be for a governmental expense, and it must be for the state government or an existing state institution. Never in the 112-year history of Nebraska's referendum power has this court applied this exception to invalidate the people's reserved power, and it shouldn't start now. None of the three mentioned requirements are satisfied here. I want to turn first to the appropriation. As was demonstrated earlier through the questioning, this is two acts. LB 1402 is a separate act from LB 1402A, which is an appropriation. Also relevant is Nebraska Revised Statute 49-804. That statute says that an appropriation shall exist when the following criteria have been met, and sub 5 is the time period during which such funds shall be expended shall be identified. We do not have this here with LB 1402. Section 1 of LB 1402, which is subject to repeal, There is absolutely a declaration in there that the legislature intends to do something. We intend to legislate funds, but it doesn't actually do that. If it actually appropriated funds, then there would be no reason to have LB 1402A, which is the actual appropriation.
If this issue hypothetically is placed on the ballot and it wins, what happens to the A bill? Is it still an appropriation out there?
I think my understanding of the legislative rules is just as if a statute's found unconstitutional or nullified some other way. The $10 million appropriation would still exist on the books and it would revert to the general fund. I don't know if the legislature has to specifically act to make that reversion, but my understanding is that this is not a remarkable proposition that something is nullified or invalidated by a subsequent legislature or found unconstitutional by the court. The appropriation just reverts to the general fund.
So are you citing a statute, or is that just an understanding that you have?
My understanding, and I'm sorry, Your Honor, I don't have a specific citation for you, but my understanding is that the legislature, basically because appropriations bills are on a biennium schedule, that is when they revert the funds back to the general fund for further allocation. But the main point is that these are two separate enactments. I also hear the relators conceding that 1402 is not an appropriation. The only way that they succeed on this one prong of the analysis is the court has to say, well, it's intertwined with another act that's not subject to repeal. I think what's notable here is that they had to create a program in order to fund it. In the natural course and ordinary expense of a state government, it would be some sort of existing obligation. So the revenue would be directly in an A bill. You don't need to create an ordinary expense of state government. They just already exist. And so if somebody...
They all have to start somewhere, don't they?
Correct. And I do think that something that starts, for example, if the legislature passed a bill saying we want to build a new building, that may be subject to repeal. That's Bartling. But over time, maybe the next year, once it's been built, now there's ordinary expenses that have to go to funding that building, and those are now non-repealable. That's another way of saying that a program can be created, and over time, you can't starve the government of its funding. And that's another point. This is
not by referendum anyway.
Not by referendum, correct. This is another teaching of Bartling, which I think that is missed in the relator's brief, which is there is a purpose. This court has announced the purpose of the referendum exception, and it's to prevent the crippling, that's the word from Bartling, the crippling of state government. In other words, if we are going to create something, if we're going to create a new branch or a new administrative body, and that's created and that exists, the people can't starve that body. They can't deprive that body of its funding. That's the whole purpose of this referendum exception. We are talking about a novel scholarship program here that has never existed before. If this is properly repealed, we'll just revert back to the status quo. I don't see how the government will be crippled by a repeal of this enactment. I also want to talk briefly about the state government prong. Again, in order to prevail, the relators have to show that this is an appropriation. They also have to meet the expense requirement, and they also separately have to meet the state government requirement. The concurrence, Justice Newton's concurrence in Lawrence versus Bierman is very instructive on this. And he says in there, and this is consistent with decades of this court's precedent, that local school districts in Nebraska are units of local self-government. They are local units of government, and there's a reason for that. Article 8, Section 1A of the Nebraska Constitution.
Hasn't that disappeared with the enormous amount of state funding that now takes place?
Well, I think 2 points on that, Your Honor. One is simply that the state simply funding education does not make it a state purpose. Again, if that were the case, then we would have another problem, which is Article 8, Section 1A of the state constitution, which says the state cannot levy property taxes for state purposes.
Well, are you saying there can be a referendum that would, on the issue of whether or not the legislature can fund state schools in the enormous amount of money that they put in state schools now? Is that what you're saying?
I think, if I understand your question correctly, if you're saying state schools, that may be a reference to...
All of the schools in the state are now largely funded by state funds.
I think Nebraska actually ranks pretty low in terms of state funding for public education. And so I think most of public K through 12 education is actually paid for by local property taxes.
I think the question is, could a referendum come in to cut off all funds from the state to the local schools? Under your theory.
I don't know. I think I would have to know a little bit more about whether that would be the ordinary expense. I do stand by the position that when the state, under the current framework, the state funding public education, and this court has said it in Lawrence versus Bierman, and it said when the state funds public education, it's not a state government purpose, so it wouldn't meet that third prong.
Where does the idea of free education come from?
That comes from the Constitution, and I think that these tax cases grapple with this. We are certainly not saying that Nebraska, the state, has no interest in public education. That would just be wrong. They do. But the way that the court has explained this process is that the state has the initial obligation. They've delegated that to local municipal governments, and we see that in the law. For example, if somebody sues a teacher, that's not the State Tort Claims Act, that's the Political Subdivision Tort Claims Act. There's other nuances in the law that recognize that education is a function of local self-government. I would be remiss to also not mention that we are talking about private schools here. This bill, the A bill, appropriates money not to a state agency, but to a nonprofit organization that sends it to private schools.
Well, the respondent gives examples of other types of tax dollars being used to transport students to private schools, textbook exchange programs. Those are taxpayer dollars. So are all of those unconstitutional?
And I see that I'm out of time.
Please answer.
We're not here saying that those are unconstitutional. What we are saying is that it is not a purpose of the state government. And I think if somebody wanted to repeal a bill that paid for busing, for example, I think that they could do it, particularly when it's going to a private institution, which is inherently not the state government. Thank you.
Thank you very much. Do we have any time for rebuttal?
1 minute, 25 seconds.
1 minute and 25 seconds. Mr. Benzer.
Your Honors, I think it's important to recognize that some of the framing by the intervener sort of shifts the landscape on what we're dealing with. So when they talk about this, for example, being a program to private schools, that's just not simply the fact. The legislative intent of this bill is pretty clear. It's scholarships to children. In the appropriations of the state legislature have a lot of appropriations where they provide state aid to individuals. So this falls in line, again, with those state aid to individual programs. And so when they attempt to reframe the text of this act, they're reframing it on their own terms and not on the legislative act itself. So
are there terms of do we anticipate, or is it in the statutes that the money can be only used in a certain fashion?
Yes, it can be used by qualifying children at qualifying schools. So
schools is kind of in there.
Excuse me?
Schools is mentioned.
Well, yeah, schools are absolutely mentioned in the bill, but it is not a scholarship. It is not funding to those schools. It's funding to the child, to the children. Similar with like other state aid programs. It's not, food assistance to a grocery store. It's food assistance to a family in need of what they have. But I would also add that if you accept the intervener's argument that they're not touching the A bill at all, that's just not the case. Because by taking to referendum LB 1402, again, their object statement is very clear. It's a direct tack on the $10 million that is within LB 1402, and then which triggers in the procedural aspects of the legislature an A bill, which helps complete the legislative act. And that has been very clearly made. That argument's been also made in the amicus brief, and I would also argue Senator Daniel Conrad, a three-term senator who opposed this bill and sat on the Appropriations Committee for years, had stated very clearly during debate on LB 1402 that this is generally, the legislature agrees this is an appropriation.
You're not contending that's some sort of judicial admission, are you?
No, I'm just arguing that the legislative history does have an impact on the judicial review of this. That's something you can look to. Not only do you have the legislature's intent in the bill, but also when you look at the floor debate, you have a senator who is very versed in the working of the legislature and appropriations, admitting very clearly that this was an appropriation, so that there's the understanding that LB 1402 itself is an appropriation, and it's one for the
If
expenses.
this is on the ballot and it passes, does the A bill survive?
Well, no, it doesn't survive, because I would say that it doesn't survive in the sense of the two are intertwined in the funding mechanism for the program is gone, because you've eliminated the program in the language that provides for the mechanism for the funding of it. So again, we argue that it's an indirect attack at the very least on the appropriation, but we think it attacks very directly the appropriation that's in the legislative intent of the bill in both Section 1.1a and Section 1.7.
Are you challenging the principle that this court has invoked, that the exception provision of Article 3, Section 3 should be strictly construed?
Yeah, so we believe that in Bartling, what occurred there was that the court in Bartling added terms to the word expense.
That's not my question.
Oh, sorry.
There's a principle that we've articulated that to effectuate the power of referendum, the exception articulated in Article 3, Section 3 should be strictly construed. Are you challenging that proposition, or do you accept it as governing this case?
No, certainly it should be strictly construed, but to strictly construe it, you have to properly construe the terms that are in the provision to begin with. And the terms in the provision are bills making appropriations, and LB 1402 is a bill making appropriations, for the expenses of state government. And again, to the extent that the court is going to look to Bartling, we think that it meets the Bartling test as is, but we would also argue that Bartling has modifying terms to the word expense in terms of ordinary running expense. But when you look at the underlying cases, they rely on other state constitutions that use those modifying terms, usual, ordinary, and usual running expenses, etc. But our own state constitution does not add those modifying terms. And so when you look at cases like Pony Lake School District, where the court has provided a canon of interpretation, the court should not modify terms, it should not add terms where there's no need to.
So your argument is that Bartling is flawed, at least in part.
Yeah, I think so. And then in part, we still meet it, we think, by its own terms, but definitely flawed. And then also, you can look to Douglas for the proper definition for expense, because in Douglas, the court did look at Bartling to say, what does the term expense mean? And it looked at Bartling and said, Bartling is one case that tells us what an expense is not, but Bartling doesn't tell us what an expense is. And so the court had to proceed with figuring out what the definition of an expense is. And to do that, they used the plain and ordinary meaning. So they looked at Webster's dictionary, and it's basically, they used a dictionary definition term there. That's basically, it's a sum expended to achieve a result. In LB 1402, is the sum expended, $10 million, to achieve a result to ensure that children have quality educational opportunities. So Douglas provides a very careful analysis and understanding of how to arrive at a conclusion of what expense means without adding modifying terms with it unnecessarily, as was done in the Bartling decision.
Douglas was not considering a definition of the term expense as used in Article 3, Section 3, correct?
No, that is correct, but nevertheless, it was trying to understand how do we understand the word expense. And so that's where you get...
Used in what context?
Well,
the salary of senators.
Yeah, it was used in this. Yeah, it definitely was used in a different context, but nevertheless, the canons of interpretation and construction that underlie that decision are important, because the court refused to misconstrue or to add terms. The court was even careful not to add modifiers that existed 2 words before the term expense. So they didn't want to say said salaries and expenses. They didn't want to say said expenses. They didn't want to add to that term expense a prior use of the word expense where they said actual expenses. So they were very careful to ensure that when we interpret this particular word, we are using canons of construction that prohibit us from adding words that aren't in the text itself, whether they're prior in the text or whether they come outside the text. And I think, again, when you look back at Bartling, the court was inserting terms ordinary running expense where those terms are not in the plain language of Article 3, Section 3. So I think Douglas governs in the sense of it helps to provide the constitutional framework for that decision.
Thank you very much. Council, that concludes arguments in State Ex Rel. Collar versus Evnan. And that concludes our arguments for the day. Court is adjourned and you are excused.